The presumption of advancement lives on. Liao versus Liao and the enduring bond between parent and child. In Liao versus Liao 2026, NZCA 250, the New Zealand Court of Appeal has confirmed that the presumption of advancement continues to apply to transfers from parents to adult children in New Zealand, regardless of the child's age or financial independence. The court dismissed the appeal on the evidence, holding that the evidence of the parties' intentions clearly displaced the presumption of a resulting trust, without recourse to the presumption of advancement. The decision follows several recent New Zealand decisions drifting from the traditional English common law position, which the Court of Appeal has now reaffirmed. In reaching that conclusion, the court weighed the orthodox English common law position against the diverging Canadian approach in Pecore versus Pecore, which it considered but declined to follow. The legal framework, resulting trusts and the presumption of advancement. The resulting trust principles are well settled. Where a person makes a voluntary payment to another, or advances the purchase price of property registered in another's name, equity presumes the transferor intended to retain the beneficial interest. Westdeutsche Landesbank Girozentrale versus Islington London Borough Council. That presumption is easily rebutted, either by the counter-presumption of advancement or by direct evidence of an intention to make an outright transfer. See the New Zealand Authority of Potter versus Potter, 2003. The presumption of advancement operates as a counter-presumption. In certain relationships, historically husband and wife or parent and child, it is presumed that the transferor intended to make a gift, displacing the resulting trust. Historically, the presumption rested on two notions: the obligation to support the other person and the natural love and affection presumed to arise from the relationship. Over time, it was extended to anyone standing in the position of a parent. The orthodox position. England and Australia. In England and Australia, the presumption of advancement between parent and child remains part of the law, even if its strength has been questioned. In Lascar versus Lascar, the English Court of Appeal confirmed that the presumption still exists between parent and child, though it described it as relatively weak, and weaker still where the child was over 18 and managed their own affairs. The Privy Council reaffirmed its relevance in Enel versus Singh, holding that, although much criticised as based on outdated assumptions, the presumption continues to form a relevant part of the court's inquiry into what the parties intended. The High Court of Australia took a similar line in Nelson versus Nelson, 1995, accepting that the presumption applies to adult children, though its practical importance may be limited where the evidence allows a positive finding of actual intention. The diverging approach. Canada. The Canadian Supreme Court took a different approach in Pecore versus Pecore. The majority held the presumption should not apply to transfers from parents to adult children, for three reasons, per Rothenstein J. 1. The parental obligation to support does not extend to independent adults. 2. The common Canadian practice of aging parents placing assets in adult children's names for financial management warranted a rebuttable presumption that the child holds the property on trust. And 3. Making dependency the threshold would create unacceptable uncertainty, given the variety of circumstances in which an adult child might be viewed as dependent. The majority also rejected parental affection as a basis, observing that affection arises in other familial relationships, such as between siblings, where the presumption has never been applied. Abelage, in dissent, took a fundamentally different view. Her Honour's examination of the historical authorities demonstrated that resting the presumption on obligation alone narrowed and somewhat contradicted the historical rationale. Parental affection, no less than parental obligation, had always grounded the presumption. What distinguishes the parent-child relationship from other bonds of affection is not financial dependency, stated Abelage, but the uniqueness of the parental relationship and the protective emotional ties flowing from it. Ties that do not atrophy with age. The shifting approach. New Zealand. In New Zealand, the presumption of advancement as it applies to adult children had continued to be recognised, and in 2019, the Law Commission, in its review of the Property Relationships Act 1976, recommended that it continue to apply, describing it as a well-established principle that provides the court with an appropriate starting point when classifying family advances. Supportive analysis also appeared in Wolf versus Kay, where Gordon J. undertook an extensive review of the authorities, including Pecore, preferred the reasoning of Abella J., and concluded that the presumption should extend to adult children, whether dependent or independent, because the traditional rationale rested on both parental obligation and parental affection. Despite this, several recent New Zealand decisions had shown signs of sympathy for the Canadian approach and a shift away from the orthodox English position. In Reid versus Castleton Reid, the Court of Appeal commented that it was difficult to see any rationale for the presumption where an adult child was well established in life. More recently, in Mackay versus Blair, the court shared the reservations expressed by Fitzgerald J. in TNVAK about the weight of the presumption in transfers to adult children, with Her Honour going so far as to see merit in the approach adopted by the Canadian Supreme Court. As the Court of Appeal in Liao was careful to point out, however, those remarks were obiter and of peripheral relevance to the decisions in which they appeared, and were made without the benefit of the Law Commission's 2019 recommendation. The present case. Background. Turning to the facts of the present case. In 2012, Ms. Liao, then 30 years old, purchased a residential investment property in Glen Innes, Auckland. Her parents, Mr. and Mrs. Liao, contributed 52,050 New Zealand dollars, approximately 29,397 US dollars, representing approximately 10% of the purchase price. 20,000 New Zealand dollars of that sum had in fact come from Ms. Liao's brother, Jimmy, and was repaid to him in 2014 at Mrs. Liao's request, so that the trial judge ultimately treated the gift as being $32,050. Ms. Liao funded the remaining 10% equity from her own savings and financed the balance of 80% by way of a bank loan secured over both the Glen Innes property and another property that she already owned. The Glen Innes property was registered in Ms. Liao's name alone. Ms. Liao's case was that she had asked her parents for help with the deposit, that her mother had agreed to give her the money, and that the property was purchased as her own investment. Mr. and Mrs. Liao, placing considerable reliance on the decision in Pecore, contended that it was they who had decided to purchase the property, that Ms. Liao's involvement was limited to taking out the mortgage to improve her credit rating, and that the property was to be registered in their names. Some years later, Mr. and Mrs. Liao asked Ms. Liao to transfer the Glen Innes property to them in 2019, and later to her brother in 2020. Ms. Liao refused, and Mr. and Mrs. Liao brought proceedings alleging that she held the property on a resulting trust. In the High Court, Wolford J. held that the presumption of advancement applied and, by a slim margin, had not been displaced, so that the parents' contribution was properly treated as a gift, and Ms. Liao was the beneficial owner of the Glen Innes property. The judge reached that conclusion against a background of what he described as a paucity of contemporaneous evidence as to the parties' intentions at the time of purchase, having turned to the presumption only after finding the direct evidence inconclusive. Mr. and Mrs. Liao appealed. The issues on appeal. The appeal raised two issues to be determined. 1. Whether the presumption of advancement applies to adult children under New Zealand law, or whether the court should adopt the Pecore approach, and 2. Whether, on the facts, the presumption of a resulting trust had been displaced by direct evidence of intention, or by the counter-presumption of advancement. The New Zealand Court of Appeal's reasoning. The Court of Appeal in Liao versus Liao expressly preferred the reasoning of Abella J. and declined to adopt the majority position in Pecore. Delivering the judgment of the court, Courtney J. gave two principal reasons. First, the court agreed that the historical rationale is not limited to an obligation of support. It reflects the unique relationship between parent and child and the fact that the emotional ties underpinning that relationship endure regardless of age. While the parent-child relationship involves moral and legal obligations, it is not reducible to them. It is the uniqueness of the relationship that justifies the presumption that parents who advance money to their children can be assumed, absent contrary evidence, to have intended to make a gift. The court further noted that if particular cultural considerations were relevant, evidence could be adduced to rebut the presumption. However, in this case, neither party sought to present cultural evidence. Secondly, the court was not prepared to assume that the Canadian practice of aging parents placing assets in their adult children's names, which had featured prominently in the Pecore majority's reasoning, applied in New Zealand, where the common practice is instead to use enduring powers of attorney. On that basis, the court concluded that, despite the reservations expressed in earlier decisions, the presumption of advancement remains part of the law of equity in New Zealand and applies to adult children, whether dependent or independent. It saw no basis for departing from that long-standing recognition by adopting the Pecore approach. Comment. Liao versus Liao confirms, on a considered review of the English, Australian and New Zealand authorities, that the presumption of advancement remains part of the law of equity in New Zealand and applies to gratuitous transfers from parents to children, irrespective of age or financial independence. It should be noted, however, that because the court ultimately decided the case on the evidence and without recourse to the presumption, its endorsement of the presumption for adult children, while authoritative and the product of careful analysis, was arguably not strictly necessary to the result. Nonetheless, for practitioners in jurisdictions sharing the English equitable tradition, including the Cayman Islands, it is helpful to see this issue resolved at appellate level in a manner that aligns with the English and Privy Council position in Enel versus Singh. The Harneys private wealth team regularly acts for trustees, beneficiaries, protectors and other interest holders across a wide variety of trust and estate matters.